All right, let's turn now to look at the statutory regime which applies, which we need to note briefly with respect to the rules of equity in New South Wales. And we're looking here at the Supreme Court Act of New South Wales 1970 and the UCP, Uniform Practice Rules of 2005, which deal specifically with equitable matters. And we note first of all section 57 of the Supreme Court Act, which provides that the court, that's to say the Supreme Court, shall concurrently administer all rules of law, including the rules of equity. All right. Secondly, sections 58 and 59 expressly preserve the availability of equitable claims and defences. What does that mean? Well, there were certain defences that were available only in equitable jurisdiction. Set off, for example, we'll come back to and look at in another lecture. All those claims and defences are preserved with the new Act. Well, I suppose it's the old Act now, 1970, isn't it? Thirdly, section 60 requires the court to recognise all equitable estates and interests and incidental equities which would have been recognised prior to the Act. So, as we'll see, we can have various equitable interests in estates in land, and the Supreme Court Act preserves those. Section 61 is important. Section 61 abolishes the common injunction and provides that where such an injunction might previously have been granted, the court may now stay an action on terms. Well, a common injunction was an injunction issued by the Court of Equity, directed to the Court of Common Law, to tell it not to proceed without taking into account various equitable claims which may have been available to the defendant. And so, in effect, as a matter of procedure, the Court of Common Law would need to take into account equitable obligations. This is at the time, of course, when we had separate regime operating. Now, the jurisdiction to provide such an injunction has been abolished, but the court may stay the action on terms. So, if you're not prepared to take into account the equitable defence which may be available, the court may stay the action. That's to say that it cannot proceed. Now, Section 5 of the Law Reform Law and Equity Act 1972 provides that if there is any variance or conflict between the rules of law and the rules of equity, the latter are to prevail. So if we've got a conflict between the rule of common law and the rule of equity, then Section 5 tells us that the rules of equity are to prevail over the common law. And then we've got various procedural provisions which look at equitable remedies. Section 66 provides for injunctions to be granted by the court. Section 67 provides for receivers to be appointed under the Supreme Court Act. And Section 73 provides for relief against forfeiture. And we'll look at all those topics in a later lecture, but they all provide a broad jurisdiction. Now remember, it's always important when you're going to court to know precisely which section of the relevant Act or regulations you're relying on. So even if you think you've looked at it many times before, always look up and just check that the court actually has jurisdiction pursuant to statute. You've always got inherent jurisdiction lurking there, but that's a pretty thin reed sometimes. That's a dangerous thing to rely on if you've got a particular provision, a particular section. Now, just note in passing, this isn't a practice course, but note Part 25 of the UCP deals with interim preservation and search, and also note practice notes in the Supreme Court Rules Equity 3 and Supreme Court Equity 8. They're both available on the Supreme Court website. They lay down a practice for the equity division and tell you how to go about running matters in that division. Right, and then just notice as well, we've got lots of other provisions in other statutes which provide for equity, and the particular area, as one might expect, is the Conveyancing Act, which consolidates all the old rules with respect to real property transactions. I don't know whether you've done property yet, but remember, the Real Property Act deals with Torrens title, a system of registration unique to Australia, while the Conveyancing Act looks to basic rules in relation to mortgages, leases and the like. And note there, Section 13 of the Conveyancing Act provides that time is not of the essence in equity. That's to say, it's not an essential term until it is made essential. And this leads to a conveyancing matter we can look at, where if you've got a contract for the sale of land, which is due for completion, parties will be obliged to complete, that's to say, hand over the money and get the documents of title at a certain date. There may be a default by the purchaser. In that situation, the vendor normally issues a notice to complete or perform, which says that whereas time wasn't previously of the essence as a matter of equity, time is now of the essence, and therefore you must perform. If you don't, then you're in breach of an essential term and will be entitled to rescind the contract, terminate for breach, and sue for damages, sue for a loss which we have sustained if it turns out that the market price, when we resell it, is lower than the market price at which we were selling the contract price. Alright, so to summarise, we've got a statutory regime here. You need to be across the statute, you need to look at the sections of the relevant Act, Supreme Court Act, and ask yourself what is being looked at in each of those particular provisions as we look at it. Now, as a matter of history, we've got to deal with a thing in passing which isn't terribly important but seems to come up all the time academically. Why, I don't know, perhaps because it gives academics something to write about. There's not a great deal of attraction about it, but it's something called the fusion fallacy. Fusion fallacy. We're looking here at whether or not the fact that there are different remedies of law and equity mean that we're still dealing with different streams, different jurisdictions, etc., etc. Well, I've already told you that one judge can give you any order that you want. Common law, equity, whatever you want, that judge can give it to you. So there's no question anymore of starting in the wrong court. That's the first point. Secondly, I suppose what we're really looking here at base is the underlying continuing distinction between certain forms of remedy which are available in equity, may not be available at law, and vice versa. And part of that may harken back to the fact that, as we've already discussed, remedies at law are as of right. You can simply go along and demand damages, whereas all equitable remedies are discretionary. And we'll look at some cases on this. Is it possible to get punitive damages in equity? Answer, no, it's not. Equity aims to compensate, to make good some default. You can't go along and get punitive damages. Can you get them at law? Yes, you can. If there's been a contumelious disregard of your rights, you can go along and get punitive damages just to punish you. That's one example of the difference between law and equity. And there are a few others, I suppose, but that's a good example. And we'll look at the case on that in a minute. Now, remember as well, as I've already said, that it's possible to have equitable interests which arise because the Court of Equity might enforce a particular obligation. And why is that? Because your conscience is bound. So, let's take an example. To have a valid legal lease of land in New South Wales, you'll need an instrument in writing, and depending on the length of it, it'll need to be registered pursuant to the Real Property Act. Okay, it's easy. So a legal lease, you've got a document, you've got a legal estate in the land, if you think of property. Can you have an equitable lease? Well, yes, you can. You have what we call an equitable lease if the Court of Equity would enforce an agreement which you've entered for consideration to grant a lease to perform. So suppose I've got an agreement with you. It isn't formally embodied in the various documents, but there's an agreement which is specifically enforceable. That's to say the Court of Equity will enforce it. In that situation, an equitable lease will arise. And we've got cases on that. The classical case is a Walsh and Lonsdale lease. Walsh and Lonsdale, the old case from the 1880s. Sir George Jessel discussing the nature of an equitable lease that can arise once you've entered into a specifically enforceable contract to grant a lease. And we've got High Court authority saying that also works under the torrent system. Chan and Cresden, which is on the reading list. Chan and Cresden is another case where the High Court, looking at what the word lease meant, said it could also encompass a merely equitable lease. Chan and Cresden's an interesting case because in that case there was a question of construction of the lease and guarantors had given a guarantee for the lease, and the question was whether or not the words the lease covered an equitable lease. That's to say one which was only enforceable. Answer, yes it did, and yes it was. Now, why does equity enforce such an agreement? Well, this is a basic rule of equity. Equity will usually treat as done that which ought to be done. That's a maxim of equity we'll come to in a moment. Equity will treat you as bound to perform if your conscience is bound. That's to say you've received something which requires you to perform. And usually the thing you've received is money or some other consideration in a contractual sense. So if the contract is sufficiently certain, and we can say that there's consideration to support the contract, then you'll be bound and you'll be obliged to pay out the agreement. And we can see a similar sort of example of that in terms of conscience if we think about a secured debt. Suppose you've got a mortgage over property. Somebody else comes along and pays out the mortgage. He or she is entitled to then stand in your shoes with respect to the security by virtue of the doctrine in equity of subrogation. S-U-B-R-O-G-A-T-I-O-N. They're subrogated to your right because it's not conscionable that the person who is owed the money is able to take the land free of the security. So in a sense, you're substituted, you're subrogated, you step into their shoes. And you can see a High Court case on that, Friend and Booker, 2009 HCA 21. Friend and Booker. All right, so you can see there equity, as there are a number of doctrines operating, and we also need to consider various maxims of equity, what we call the maxims of equity. Now, what's a maxim? Well, a maxim is a sort of very short, pithy saying, which summarises something important. And I guess a lot of modern writing says there's no point in looking at maxims of equity or anything else. Time's rolled on. When I was a boy, we learnt them all by heart, and I still think they're pretty useful. They're useful because what they do, if you unpack them, is summarise precisely what you need to know with respect to basic equitable doctrine. So you can't just parrot them off, but if you look in court and the judge says this maxim or that maxim, as he probably will, then it's useful to know precisely what is being meant. Now, our first maxim we need to look at is that equity will not assist a volunteer. A volunteer is someone who's given no consideration for a particular transaction, a mere donee, if you like, of a gift or whatever. And the maxim really is a longer one, flowing from the famous judgment of Lord Justice Turner in a case called Milroy and Lord. The maxim is that equity will not assist a volunteer by treating a failed gift at law as a perfect declaration of trust. What does that mean? Well, let's think back to our basic propositions. A gift at law, to be valid, usually requires an intention to give, an animus tenandi, and physical delivery. We know that from old cases. You must physically deliver. It may be that the gift at law fails for some reason. And as we'll see in a minute, it usually fails because there's some third-party requirement which hasn't been satisfied of registration. But the gift fails at law. The Court of Equity, of course, could say to the donor, that gift has failed as a legal matter, but we are still going to compel you to hold the property on trust for the donee, and therefore, although you're not a donor, you are effectively the settlor of a trust in favour of the intended donee. So you can see there you've got two possible regimes running side by side. We've got donor, gift to donee, or we've got trustee holding property on trust for beneficiary. But Milroy and Lord tells us that we are not able to treat a failed gift at law as a perfect declaration of trust. Well, how does that arise in a modern context? It arises usually because under the Torrens system now, under our real property system, you need a step to be carried out before the legal gift or legal transfer is perfected. And that step, of course, is registration. And we've got various cases, of which Corrin and Patton on our reading list is the main example, where the donor intends to transfer property to the donee, but fails properly to carry out all the steps which are necessary for registration. So the donee has got hold perhaps of an instrument, but is unable to take it along and perfect the gift or register it. In that situation, will equity intervene to treat it as a declaration of trust? Answer, no, it will not. And so those sort of cases, Milroy and Lord, Corrin and Patton, are all examples where, as I said, usually something extra is required to perfect the legal validity of the gift. In Milroy and Lord itself, there was an attempt to transfer company shares, but as a legal matter under the Companies Acts in those days, property could not be transferred until the shares were registered in the books of the company. That didn't happen. Was it a valid gift? Answer, no. Similarly, in Corrin and Patton, there was a need to procure the delivery up of a certificate of title. If you look at it from a property point of view, in order to register a Torrens transfer, you need a valid transfer, of course, an instrument, registrable instrument, and you also need to produce a certificate of title to the Registrar General. If you couldn't do that, then you couldn't register the gift legally or the transfer legally. And without that, you don't have a failed gift, and without that, you don't have a valid transfer in equity. All right. Well, that's a basic rule of equity. Equity will not assist a volunteer. And that problem arises probably 3 or 4 times a year, unfortunately. People don't go through all the processes. They want to make a valid gift, and they fail to do so. Now, maxim number 2. Equity treats as done that which ought to be done. Well, we've already seen an example of this. Equity is looking all the time to the question of conscience. And so equity will require you to carry out an agreement which is sufficiently certain, which is supported by consideration. And we've got the classical cases of Norman and the Federal Commissioner of Taxation and Shepherd and the Federal Commissioner of Taxation. Both cases, you remember, where Sir Victor Windia looked at the question of future property and the transfer of an interest when we have consideration supporting the particular transfer. If you've got consideration, then equity will enforce the transfer and require you to perform. If there's no consideration, the question becomes more difficult, which of course is what Norman's case was looking at. As we saw a minute ago as well, we might have the creation of an equitable lease. Walsh and Lonsdale, Chan and Cresden. We've got a situation where you agree to enter into a lease. For some reason there's no legal lease entered, and then the question arises whether or not there's still an interest which can be enforced. The answer is yes, it can, so long as there's sufficient certainty with respect to the contract to make it enforceable. And we'll also notice there that we have the doctrine of constructive trust, which we'll come back to and spend a couple of hours on. A constructive trust will arise when equity requires you as a matter of conscience to carry out some transfer or to hold property for somebody else. Classic example in our legal system in Australia is where someone who's an employee steals money, steals property and makes off with it. Is there any express trust there? No. There's obviously no trust because he's an employee. But is the employee in breach of a duty? Yes, the employee is in breach of a duty. And the Court of Equity will treat as done that which ought to be done. And what ought to be done there is to hold the property on trust for the employer. That's the basic proposition, the basic rule. Then we've got to note that equity will intervene to enforce an express negative stipulation in a contract. Equity will operate to assist someone who is relying on a contract to preserve their contractual rights if there's an express or implied negative stipulation in the contract. And there we've got the old cases, Lumley and Wagner and Warner Brothers and Nelson. Mrs. Nelson, Betty Davis, attempted to break her contract with Warner Brothers. Could they force her to work? Answer, no, they could not force her to work. Why not? Because contracts of employment aren't specifically enforceable. But could they prevent her from working for anybody else because of a negative stipulation in her contract? Answer, yes, they could. She contracted to work for them for 4 or 5 years, 1937 to 1942. By an injunction, they could stop her working for anybody else. And Lumley and Wagner, the same sort of situation. Someone offering to be an opera singer, could they stop her working for anyone else? Yes, they could. So that sort of situation arises quite often in a contractual context, and you've got to look to see whether there is indeed a negative stipulation in the contract. Usually you'll be prevented from taking action in breach of a contract if you've contracted to do a particular thing. And I've given you a recent case there, Tullett, Prebon and Purcell, 2008 NSWSC 252. Long discussion there about stockbrokers, high rolling fellas, of course, out there making a lot of money. They're suddenly offered even more money. They decide to jump ship. Can they do that? Well, no. They've got a contract. They must obey that contract. They must work out their particular gardening leave or the notice period before they can move. Now, another maxim. Equity will assist those who are alert, not asleep. Lege seveniunt vigilantibus, non dormientibus. Think back to your Harry Potter. I'm a sleeping dragon, Draco vigilans. Draco non dormiens titilandus, don't disturb a sleeping dragon. Well, the Court of Equity requires you as a discretionary matter to be up in court complaining about something as quickly as possible. If you've got a particular complaint and you want equitable relief, as a matter of discretion, you must not delay in getting up to court. You've got to be up there as promptly as possible, seeking relief from the judge. And if you delay even for 2 or 3 days, that may be too long because the judge will think, well, the matter wasn't quite as serious or as urgent as we thought, and therefore I'm not going to give you any relief. So, equity assists those who are alert, not asleep. And we've got related doctrines there. We've got the doctrines of laches, waiver and acquiescence, which interrelate to a certain extent and provide for delay to be a discretionary reason for refusing relief. Laches, L-A-C-H-E-S, is a doctrine which says that if you let something go, you forget about it, you don't do anything, then the Court of Equity will not assist you. Waiver, you might waive your right. You say, I know I've got a legal right, but I'm not going to complain about it. Or acquiescence, you might acquiesce in a particular course of conduct. If you do so, then you will lose your entitlement to complain. Now, those are all useful English words, but you'll see if you look at the case I've given you there, agricultural and rural finance and the gardener, that the terms are opaque, to say the least, and overlap a lot, and it's difficult in a court to say which particular doctrine sometimes you're relying on, because they tend to merge into each other, they tend to blend together. Nevertheless, We'll look at that a little bit, but you need to be aware of those doctrines. And they tie back, of course, to the question of acting promptly. And if you don't act promptly, you may well be guilty of laches, or you may have waived your right, or you may be acquiescing in the misconduct by the person about whom you're complaining. Now, another maxim, equality is equity. Usually when we're looking at the enforcement of a trust or dividing up property or whatever, we try to rely on the doctrine that equality, treating everyone equally, is equity. That is the fair way to go. And we'll look at some recent cases on that. Suppose, for example, you've got a case where a large investment group has collapsed. We've got various rules which we'll look at in terms of working out who owns what money. There are certain rules which suggest that the people who have paid in first have taken their money out first, and therefore they lose. So the people who come late to the party are the ones who are in the best position. We've got cases going every which way on that sort of topic now, but as a basic rule, equality is equity. The fair way to treat all members of a common group or a common fund is to treat them all equally by giving them all a pari passu share, that's to say, an equal proportion of the amount which they're owed. And then just look at our last maxim here, once a mortgage, always a mortgage. What does that mean? Well, equity is always looking to the substance, not the form of a transaction. So if a transaction is designed to be a security for money, that's to say you're expecting to pay it back and get the property back after the transaction is finished, then equity will always treat that as a security. You won't be able to turn yourself into a buyer of the property. And that can be important, because if you've got a mortgage, you'll always be in a position to redeem the mortgage. To redeem it means to come along to the lender and say, here is your money, give me back my property. And that can be particularly important because as markets rise and fall, you may find that the market recovers and you're able to pay back the loan and get back a property which has risen considerably in value. If the lender can simply make off and sell it or treat it as his or her own, then you have a problem because you've lost your proprietary interest in it. Now, you'll see in the note there are various ways you can redeem a mortgage, and also the lender can foreclose on a mortgage. The lender can come along and get rid of your entitlement to redeem. The entitlement to redeem in property law is called your equity of redemption. If you borrow money, you will always have an equity of redemption. But at some stage, the court, by a court order, may close out your equity of redemption, in which case the person who is lending to you will become the absolute owner of the property. Alright, so to summarise there, we've got various maxims of equity. They're useful little tags. I find them useful because once you've got them in your mind, you can think, yes, what particular application are we using here in terms of equity? How's it all working? Right? Equity will not assist a volunteer by treating a failed gift at law as a perfect declaration of trust. So equity won't intervene in that situation. But equity will treat as done that which ought to be done. Equity will intervene to compel you as a matter of conscience to carry out a promise which you've made in return for consideration. Equity might intervene to stop you breaching a stipulation in a contract. You've promised solemnly with consideration to do something. You can't then just turn around and say, I'm off, I'm out of here. The court, of course, isn't specifically enforcing the contract. All what it's saying is that you can't go and do something else, and therefore you may be encouraged to perform the particular contract. A very important practical doctrine or maxim, equity assists those who are alert, not asleep. So you've got to be on the alert there. If you've got something in court, get up to court promptly. If you delay, there'll be a problem. Equality is equity. Equity looks to treat everyone who's in the same situation equally. It doesn't like people being treated unfairly or being put into a separate class. And then once a mortgage, always a mortgage. If you've got a mortgage, then you'll always be able to redeem it up until foreclosure has occurred, and the Court of Equity looks to redeem because in substance the matter is only a security interest, not an out-and-out sale of the property. We've had quite a few cases involving shares and the like during the GFC.